Good afternoon, everyone. My name is Jeremy Herman. I am an employment lawyer at Samfiru, Tumarkin, LLP. I'm located in Toronto. It's great to be back in the new year with you all. I've done many of these Q&A sessions, live Q&A sessions in the past. And so it's, like I said, great to be back. And I hope everyone had a great holiday season. As you know, we have offices across Canada. So as I said, I'm in Toronto. We have an office in Ottawa. We also have one in Calgary, Alberta, and in Vancouver, British Columbia. And if you have joined with us before, then you would know, and if you're new, then you'll learn that these Q&A sessions are really an amazing opportunity for all of you to get your employment law questions answered live. This is free. It could be anonymous if you'd like, and you can post whatever questions you might have about employment law issues, about workplace issues, and I'm here to answer them for the next half an hour. So please don't be shy. Ask your questions and really utilize this opportunity that you have now to learn about what your employment rights are. As I normally do, I like to start off my Q&A sessions by talking about an important topic. It's usually a hot topic that's going on right now and that impacts workplaces. And so what we'll talk about is going back to the office, and that is employers requiring that its employees come back to the office. When COVID was coming to an end, the pandemic at least, we saw a lot of employers requiring that employees come back to the office. It could have been part-time, it could have been full-time, it could have been on staggered schedules. We saw a variety of mandates from employers regarding coming back to the office. And some employees continue to work remotely. And sometimes it depends on what level you're at the company, what position you hold. And we're continuing to see that more and more employers are asking their employees to come back to the office. And some employees are fine with that. And in fact, they might be happy with that. They're sick of working from home. And some employees might be unhappy with that. They really enjoyed the flexibility associated with being able to work from home. If you're a parent, then it might be easier to have that flexibility to be able to pick up your children, et cetera, from school. So where does this leave employees? Do employees have to go back to the office? Are they required to do so? Can their employer require them to come back? And what happens if you don't and you're an employee and you choose to not come back to the office when your employer is requiring you to do so? And so really the answer is that it depends. And that's often an answer in the law. And it depends on the situation. It depends on how long you worked remotely. Were you working remotely prior to the pandemic? Have you always worked remotely? Or was it something new that occurred around the pandemic or during the pandemic? And now the employer is asking you to come back to work. When you did begin working remotely, was it communicated to you that this was going to be a long-term thing? Is it a term of your employment that became permanent? Or is it something that was always understood to be temporary? So all of these things are relevant, and each person's situation is different. If you're someone, for example, who's always worked from home, and now your employer is requiring you to come to the office, well, then that's a significant change to the terms of your employment, because you always had the opportunity to work from home. It had nothing to do with COVID. So if you're being required to come back to work, then you can treat that as a termination of your employment, and you can seek your full severance pay. That is what we would call in the law a constructive dismissal. And I'll get into constructive dismissals in more detail throughout this session today. On the other hand, if you are an employee who just started working from home a little while ago, maybe you didn't even work from home full time. It was only half time. It was only maybe 2 days a week out of 5. And now you're being asked by your employer to come back 5 days a week. That's a different situation. It was not permanent. If it was expressed that it would be temporary in nature, then it's a different situation. If your employer is requiring you to come back, you probably would have to come back to work, and your employer is within their right to ask you to come back to work. So if you're facing this kind of situation, as many employees are, contact us. If you're unsure whether you have rights in your circumstance, make sure you contact us. You can contact us at helpandemploymentlawyer.ca, and we have tons of resources. As you see on the screen, look up employmentlawyer.ca, and you can find those resources. And we definitely have resources online about this topic. So that is the opener for today, and now I will get into some of the questions that are waiting for me. So we have a question from Ray on Facebook. Can a manager clock you out of your shift early while you are still working? So it depends on what the circumstances are. Why is your manager clocking you out of your shift? You do have an entitlement in most cases to work a certain amount of hours, a certain guaranteed amount of hours. If you're not going to be paid for the amount of time that you're now being clocked out of, that could be a problem. It could be a situation where you don't have a guaranteed amount of hours. So clocking you out may not be a legal issue. It really depends. So it depends on if you're being paid, if you're not being paid. If you are guaranteed a certain amount of hours and you're not going to be paid because your manager is clocking you out early, that again, it could be a situation of what we call a constructive dismissal, a change to the terms of your employment, especially if it happens more than once and it becomes a bit of a pattern. That's certainly legally problematic, and you should contact us and we will help you work through that issue. Okay, Ray, I hope that satisfies your question. And if you have a follow-up, please ensure to post it in the chat and I'll try to get to it. We have another question on YouTube from Colleen. Can an employer force you to take a leave of absence? No, they can't do that. That's the general answer. It, again, depends on the situation. Usually a leave of absence is something that the employee wants to take. It could be a medical leave of absence or another type. It could be a bereavement leave if someone has passed away in the family and you're taking time off. There could be a situation where you are under some sort of investigation because of perhaps misconduct that you think your employer engaged in, that your employer rather thinks that you engaged in. And in that situation, they might put you on an unpaid or a paid leave of absence. Okay. But if you don't agree to the leave of absence, you do have rights in that situation. Again, it's another situation where the employer is fundamentally changing key terms of your employment. And if that happens, you could be entitled to your severance pay. You can treat your employment as having been terminated. And again, that's a constructive dismissal. And your severance pay might be as much as 24 months of pay. Okay. We have another question on YouTube from Sylvie. We were given 2 weeks off for holidays, and we were told we were given 2 weeks off for holidays, and we were told we would be called back, but we don't know when afterwards, and debating if I should apply to EI or take it as a termination. Okay. If you're given 2 weeks off for holidays, you should be returning to work after the 2 weeks off. If you were laid off, if that's what you're referring to, Sylvie, and you were laid off, you don't know exactly when you're going to be recalled back to work, then you can treat that as well as a termination. That is potentially considered another constructive dismissal, where your employer is telling you you're being laid off. So long as you have not consented to the layoff, then you can treat it as a termination. But that consent piece is very important. If your employer has told you that you're being laid off and you say that's fine, then you can't then come around and say, well, no, that's a termination. Okay, because you've consented to the layoff. If you were never recalled back to work, then you can treat it as a termination, because eventually your employer has to recall you back to work if they temporarily put you on a layoff. And if you are on a layoff, or if you're terminated with respect to your EI question, so you can apply for EI. And if you need that financial assistance, you should do so, and you should do it promptly. So Sylvie, I hope that answers your question. If you have a follow-up, as I've mentioned, please ensure that you post it in the chat, and I will try to get to your follow-up question. Okay, we have a lot of questions coming in, which I'm very pleased about. Let us move on. We have a question from Angel on YouTube. Our company was bought out by another large healthcare company. They're switching people to a call center environment and ignoring any medical accommodations. Is there anything that can be done about this? Absolutely. There's a lot involved in that question, Angel. So we'll try to break it down. So if your company is bought out by another company and your employment is being maintained, so it's not like you're losing your job as a result of the company being bought out, but they're switching an employee's duties, right? An employee might be getting a different position or tasks because of the company buying out your company. In that situation, then that is another constructive dismissal. You can say, I don't agree to that. I don't agree. I worked a certain position working for my company for X amount of years. Now, just because the company is being bought out, if I'm being told that I have to do significantly different work, you don't have to accept that. And you can treat that as a termination. There could be small things that change, right? When one company buys another, you might be, told to do a little bit, some work that's a little bit different. In that case, you may not want to challenge that. You don't have so much legal recourse in that situation. But if there are significant changes, then you absolutely do have legal recourse. Another thing that comes up is when one company buys another company, it's often an opportunity that an employer uses to offer employees a new employment contract. If that is happening to you, do not sign it. Make sure that you contact us immediately, because usually that new employment contract will have new terms of employment that are not usually favorable to the employee. And you should understand what you're signing, of course, before you sign it. And you should understand how it impacts your employment and your employment relationship. So definitely do not sign that contract if you're being offered it. Tell your employer, and they should be telling you this, that you have some time to review the contract, review it with a lawyer, and you should take the opportunity to do so. Now, Angel, you also brought up medical accommodations. So if there are certain employees, perhaps such as yourself, who has been accommodated in the past, you might have a certain diagnosis and that prevents you from doing certain type of work, and you're being accommodated, those accommodations have to continue. Okay, if you're going to continue doing the work that you were previously doing and you require those accommodations, just because there's a new company involved doesn't mean that those accommodations should not continue. And if they don't continue, that is a human rights issue. Okay, that is against our human rights code, and you can definitely seek legal recourse for that issue as well, aside from the termination, aside from the severance, right? They're two separate, distinct problems. Your employer should be accommodating you. If you need an accommodation, you should be getting a doctor's note. The doctor's note should identify what the proposed accommodations are, and your employer should be accepting that note and trying to accommodate you to the best of their ability. And there are very rare circumstances where your employer cannot accommodate you, and that is legal. So if you're being told by your employer that they cannot carry out any of the accommodations, again, ensure that you contact us, because it's rare that is legally permissible for your employer to do that. So Angel, I hope that answers your question, and please post a follow-up if you have one. Okay, let's move on. We have a question on YouTube from Nathan. I've been an independent contractor with a large company for 3 years, with my contract renewed annually. This year, they chose not to renew. Am I eligible for severance? Could they have misclassified you? Absolutely. They may have misclassified you, Nathan. So for everyone else, so that you understand what Nathan and I are discussing, it's not uncommon at all for an employer to try to classify a contractor, or rather an employee, as a contractor. So it's a very common thing where you're told that you are a contractor. You might invoice the company and that's how you're paid. You may not be on payroll. You could have an HST number, and you're paid that way. And you could even sign something that says that you are an independent contractor. You're agreeing to that. But that is not legally true in all cases. Even if you invoice the company, even if you sign something, the law might still consider you to be an employee. And employees have significantly more rights than independent contractors do, and more rights and entitlements, which is why employers, it's not uncommon for them to say, we're going to classify you as an independent contractor. One key reason being, if they ever let that person go, they don't owe that person severance, because independent contractors are not owed severance. Only employees are. Okay. And so if you are being told that you are an independent contractor, and even if you might agree to that, remember that it may not necessarily be true. So Nathan, in your case, you could have been misclassified. I can't say for sure. I need more details. So definitely contact me. I'd be happy to arrange a consultation with you. You can contact us at help@employmentlawyer.ca, or you can try contacting me directly as well. You can ask to speak with me, and I'd be happy to give you a consultation. You see my contact information on the screen right there with the QR code. So please scan that, contact me, and we'll talk about whether or not you are likely a contractor or an employee and what rights you might have. And like I said, very common. I have a case going on right now where I'm dealing with that issue, right? I had a contractor supposedly who was working for a company for almost 10 years. They were let go. They weren't offered any severance. And I got that person's severance because really they were an employee. Their employer didn't understand that. Now the employer does understand that, and the employee received their entitlement to severance pay. Okay, Nathan, if you have a follow-up, please be sure to let me know. Okay, let's move on. So we have a question from Jay on YouTube. Are companies legally required to give you a copy of your employment contract when you start, or if you ask? And what happens if they don't, won't? Does that vary by province? So generally, a contract is something that two parties engage in. Two parties are involved, at least two parties in a contract. Okay, so if you are a party to the contract, you are entitled to a copy of the contract. You can't know what you're signing or what you're agreeing to without a copy of it. So yes, if you don't have a copy, you should be provided with one. And if before you sign it, you of course should see what you're signing. And again, don't sign anything unless you first contact us and have us review the contract, because you don't know what you're signing. There could be terms in there that are very unfavorable to you. It's very, very common for that to occur. You could be provided with a new contract, as I mentioned earlier, during the course of your employment, or it could be as normal when you're starting out a new job, that you're provided with a contract and you're asked to sign it. So please ensure that you have that reviewed by a lawyer at our firm. You can contact us again at help@employmentlawyer.ca. Okay, let's move on to our question on Facebook from IA. My employer recently terminated me over the phone. I worked there for a little over 2 years. I've not received any form of a written notice. Can my employer rescind their termination? I've decided it's for the best and do not want to return. Do I have to accept if they do change their minds? Okay, so if you've been terminated, then you're owed severance pay, first of all. You're owed notice, or in other words, severance. And if your employer then decides to rescind it, you don't necessarily have to accept that. I would say it depends on how the termination was told to you. Was it in writing? Was it over the phone? In this case, it was over the phone. Was it clear that you were being terminated? And if it's rescinded, no, you don't have to accept that necessarily. It could impact your severance pay if you don't accept it. But the basic thing that everyone should understand is that if you are terminated, you are owed notice of termination or severance pay. And so be sure that you contact us when you're offered that. Or if you're not offered any severance pay as well, be sure that you contact us because you should be provided with that offer. And we can discuss whether it's a reasonable offer. Now, we talk a lot about severance, and it's a good opportunity now for us to discuss our firm's tool known as the Pocket Employment Lawyer. So if you go to pocketemploymentlawyer.ca, as you see on the screen, you can easily, and it's a free tool, it's anonymous, you can easily find out how much severance you are owed given your particular circumstances. So part of our Pocket Employment Lawyer tool is what's called a severance pay calculator. The calculator will ask you, again, free and anonymous, it will ask you questions, basic questions about you and your employment situation. How old are you? What position did you work in? How much money did you earn? How long did you work for the company? These basic questions allow us to determine how much severance you would be entitled to. You can use that tool whether you've been terminated, whether you think you might be terminated soon, or if you have no idea that you'll be terminated, you don't even think you're going to be terminated, you're just curious to know, given your circumstances, how much severance would I be entitled to? So please check it out. Again, the severance pay calculator. Okay, we have another question from Chrissy on YouTube. If you aren't brought back from a parental leave, how do you go about proving that it is discrimination? Okay, so if you're on a parental leave, everyone should understand that you are entitled to your job back. Okay, your employer has to hold your job for you for a certain amount of time. If it is within that time and you write to your employer and you say, I want to come back to work, and your employer does not offer you your job back and they terminate you, again, you would be owed severance, but that is also potentially a human rights issue, as Chrissy mentioned, and it would be a breach of other legislation which requires the employer to hold the job for you. Okay? If you're terminated in this situation, which I have dealt with many times, it doesn't change the fact, of course, that you're owed severance pay. In terms of proving it, well, it's always ideal, Chrissy, to ensure that everything you have is in writing. Try to correspond with your employer in writing only. Don't do it over the phone. And if you happen to have a phone conversation with someone from your company, make sure that you follow up to that phone conversation in writing. And you would say something to the effect, further to our conversation today, we discussed as follows, right? It's not as good as having the whole conversation in writing, but it's still helpful if you have a conversation over the phone or in person to have that written follow-up. Okay, and make sure, importantly, that you keep all of that documentation, keep all that correspondence. Send it to your private email so that you have a copy of it always. And then contact us, and we will ask to see that documentation. And of course, we'll want to learn more about your situation. When did you go on the parental leave? For how long? And what position were you in, etc. And then we will be able to advise you further on what your rights are. So Chrissy, I hope that satisfies your question. And if you have a follow-up, as mentioned, please post it in the chat. Nathan has a follow-up question. So Nathan had asked about if he's an independent contractor, is he entitled to severance pay? And we talked about how it's very common for employers to misclassify employees as contractors in order to get out of paying them severance pay. So Nathan now asks, as a follow-up, he worked his full 2023 contract, but the company chose not to renew it in 2024 due to a lack of work. Would I still qualify for severance? Yes, you would. Okay. The company's still around. They haven't gone bankrupt, but they just, for one reason or another, in this case, it's a lack of work, they chose not to renew the contract. If you are deemed to be an employee at law, Nathan, then you will be owed severance pay. If there's a lack of work and you really are an independent contractor, you won't be owed severance pay. But we have to find out whether you are or you're not an employee to determine whether you have entitlements upon termination. Okay. So again, Nathan, contact me and I'll be sure to help you out. Okay. Let's talk a little bit about another hot topic, and it relates to other things we've talked about today, and that has to do with mass layoffs. And Google is another company now engaging in layoffs. They're scaling back in various departments, and a lot of them are working on contract. So as we talked about, if you're a contractor, you might still be owed severance pay because at law, according to the law, you might really be an employee. And also important to note, there's no one-size-fits-all severance package. It's very common for employers who engage in mass layoffs to treat all the employees very similarly. So all the employees who are being terminated, they're provided either an identical severance package or a similar severance package to each other. And really that should not be the case, because your severance depends on your situation, depends on your circumstances, how old you are, how long you've worked for the company, what position you were in, how much money you earned. These are all relevant factors to determine what your severance rates are. So for a company to engage in mass layoffs and then to say everyone is owed 2 months of severance, 2 months could be a lot for one person and it could be very, very little for another employee, right? A more senior employee, an older employee, etc. So if you are an employee who's experiencing a mass layoff, or you have been terminated and everyone's being offered a similar severance package, again, make sure that you contact us. We will let you know whether the severance offer is adequate or not. In many, many cases, it isn't, and we will help you out in that situation. Okay, let's see if we can get to another question. So we have a question from Glenn on Facebook. If you are off of work on disability for over 2 years and are now able to return to work, can your employer change your duties from your previous job and change your hours from 8 to 12 hours? So Glenn, it depends. It depends on whether this is an accommodation or not. If your employer thinks that, or really if your medical professionals who are treating you think that you need to have an accommodation whereby you work different hours or fewer hours or whatever the case might be, then your employer should implement that accommodation. And as we talked about earlier, they're actually required to implement it. Otherwise, they could be facing discrimination and human rights allegations. So that would be, certainly be problematic. So Glenn, if that's the case for you, then let us know. Absolutely. Okay, Kim lastly has a question on YouTube. Can my employer cut my hours from full-time to part-time after 16 years and give my hours to someone else? No, Kim, they cannot do that. That's a constructive dismissal. Make sure that you contact us, Kim. You definitely have rights in that situation. Okay? help@employmentlawyer.ca. It was great being with you all. I'll see you again soon. And we have another employment law question and answer session tomorrow at 1:30 p.m. With my colleague, Dan. So make sure that you tune in for that. Take care, everybody.